And welcome back. It's time for Opinion Courts, and you can get in touch with us on 22422, which is our SMS line. And I want to start by introducing our panel to you for two topics this evening. Judy Thongori is a prominent family lawyer, and she'll be speaking to us tonight on matters relating to the decision on matrimonial property that the High Court issued this week. And later on, we'll be joined by, I should begin with Mercy Wanjao, who's the acting legal director for the Communications Authority. Next to her is Edward Kisiangani, our resident political analyst. To my left is city lawyer Steve Ogola, and next to him is the elephant in the room, Patrick Gadara, curator of the Elephant blog. He is our cartoonist and regular contributor on the show, and you're all welcome to the program. Judy, let me begin with you. This week, the High Court ruled that a provision in the Matrimonial Property Act that requires family property to be shared according to each spouse's contribution is constitutional. The judge ruled that there was no basis to claim that the section discriminates against women, as a women lawyers body, FIDA, had put before the court. Having said that, where does that leave us in law? Has anything changed?
No, nothing has changed, Anne. What happened is that FIDA went to court seeking to increase the rights available to spouses. At present, and since the end of 2013, we have the Matrimonial Property Act that provides that contribution could be financial or non-financial. Non-financial contribution includes childcare, companionship, domestic work, working in a family company, and just about everything that you can think about in support of a family. But it left the discretion to the court to determine what percentage would be put on either the financial or non-financial contribution. So FIDA Kenya went to court seeking to have the percentage settled, that it would be 50-50 in respect of matrimonial property, irrespective of the contribution. That is a case that was lost.
Okay. And does this decision, as some have opined, discriminate against women in any way in a country where the role of homemaker really isn't valued?
I think the persons who discriminate against women are us people, because we do not value our families as we should. If we considered that our families are the most important, by the way, shall I say, Article 45 of the Constitution says the family is a fundamental unit of society and the basis of social order. Mm-hmm. If we practiced that, then it would mean that whether a person goes out to get bread because it's necessary to do so, or a person stays home to take care of the family, their contribution is equal to the family. So unfortunately, we discriminate, and I guess you can say by extension that's what happened yesterday. But I was saying, irrespective of what the High Court finds, this nation needs to start having a very serious dialogue. Only yesterday, the Swedish embassy celebrated dads, Kenyan dads and Swedish dads. And what they were trying to bring to the fore is the importance of having fathers participate in children's lives, especially at the very formative stage. I was shocked to learn that in Sweden, after the birth of a baby, they don't call it maternity leave. They call it parental leave. And a family is entitled to 480 days in total.
Wow.
The first 90 are distributed equally to the husband or to the father and the mother. The others, they may share as they wish. The more equally they share, the more bonuses you get. And by the way, that leave is paid. What am I trying to say? Such a society recognizes the fundamentality of the family. You know, Anne, even what you're going to be talking about later, cyber crimes, about all the things we talk about in this country.
Right.
Sometimes we forget to ask ourselves, why are we where we are? Why are we trying to correct what ought to have been corrected at the very formative stage of a person? And that is a family. So I say the nation does need to have a dialogue on how important bringing up a family having both parents present and having them participate is to the future of this nation.
Right. It's a values issue, I mean, that we keep talking about. And you've rightly said, I mean, when we talk politics or anything else,
Yes,
it really boils down to the family, because
Indeed.
even our politicians are members of families, aren't they?
Indeed.
I want to just return to our topic, and you talked about spousal contribution, and in fact, and the judge did make reference to that,
Yes,
you know, the
yes.
court still provides for this to be assessed. So if you would define that for us, and the parameters that are used by the court when, you know, determining what one's contribution has been.
Okay, the discretion has been with the judge, so to speak. But allow me in a minute to just give you a bit of history so that we appreciate this. Until 2013, we didn't have a local act on matrimonial property, important as it is. We borrowed from an 1882 English Act. Up to 2007, it was quite accepted that contribution would be financial and non-financial. In 2007, the Court of Appeal decided the famous Isharia case and determined that contribution had to be financial. And so that if you didn't show 50% of financial contribution, you didn't get 50% of the property. At that time, we became very busy having our own local legislation. And that's the one that saw the light of day in 2013, at the end of 2013. And that's the one that now provides for non-financial and financial contribution. Now, the judges are left with the discretion of determining how much to apportion to each person's contribution. But I can tell you that in most of the cases that have been determined in the year since the beginning of 2014, because the act became law at the end of 2013, we are seeing more of a 50-50 contribution. Because even for the person who stays home, the courts have begun to recognize what I was just saying, the need for the family to be supported in the manner that they are supported, okay? And even many of the people who stay home, you probably find an element in which they also bring in the bread, you know, if you like.
Yeah.
So I think we are moving to a point where even if this case does not succeed on appeal, I'm almost certain that this nation going the way it is going to a point where it's going to say it is 50-50 as long as you show that you supported the family.
All right. So, and to my broader panel, anyone wants to make comment on that? Steve, you're looking at me like I should not look at you, and I am.
My only comment is to self-advise. You know, my learned senior is a thoroughbred family law practitioner.
Yes.
And once she speaks definitively on these matters, and therefore mine is just to endorse and to associate myself with those able comments that she has articulated.
Running for office anytime soon? Okay, Prof, what do you think?
Two things. I think the distinguished lawyer has put it rightly, that we are going to reach a point where there will be a bigger conversation on how best this can be done. We don't need to create an acrimony. And I think the law will evolve, and with the new challenges that are coming ahead, we are likely to have such a kind of thing, and maybe there will be a better ruling than the one we have had, because there are so many underlying issues which we need to think that might have been overlooked in the ruling. But I just want to point out with a lot of humility to the distinguished lawyer that in Sweden, the example she has given, the reason why there's a huge leave for spouses is in fact for the last almost 40 years, Sweden and most of the Nordic countries have had a problem of population. And in fact, people in the Nordic countries, people are encouraged to have children, because there has been, interestingly, across the world, growth in the population, but there has not been growth in the population in the Nordic countries the way they want it to be. So therefore, guys who don't get married are overtaxed for not doing that. So that is the reason why Sweden is like that. And unlike in Kenya, where we want to control the number of children we have because there is a population explosion, Sweden is the contrary. So our challenge in Kenya is different from the one that you get in the Nordic countries. That is the only thing that I would point out. But the rest of the stuff, excellent.
Anyone else want to comment?
What I would say is, without speaking to the law itself, I fully agree that as a society we need to make certain decisions. And I think that valuing the contribution of women, and it's not just women, there's also stay-at-home dads who would be affected by this. I think we need to really put up and heighten our appreciation for what that constitutes and the contribution that gives. The second thing I would say is we've got to go beyond just married couples. I know this is a law about our marital property. Also to start to think about the burdens we impose on single-parent families. You know, we have situations where girls are fired from work, you know, when they get pregnant, you know, they lose their job, you know. And so these are sort of things that really we need to start seeking legal remedies and providing legal protections for people. I think, again, going beyond that, to start thinking about how we deal with reproductive rights. You know, another very big issue, things like abortion, etc., which keep killing women all the time. I think the last time I read it was about 30,000 that we lose. You know, so it's serious. It's a serious thing. Our laws right now, as they are, especially on the abortion front, really do hurt more than they help. So I think we really need to, it's a conversation that needs to come up and be discussed.
All right. Judith Ongori, thank you for your time. She is a prominent family lawyer. And now to our second topic of the evening, which is the Computer Misuse and Cybercrimes Act, which was assented to by President Uhuru Kenyatta. And let's just show you basically what it says, and we can quickly give you some of these cyber offenses, including espionage, false publications, child pornography, computer forgery, computer fraud, cyber stalking, and cyberbullying. I don't know what I'm going through. Cyberbullying, all right? So those are basically the offenses there. And let's just sample some of the jail terms: sharing fake news or hate speech, a fine of 5 million shillings, a jail term of 2 years; sharing pornography, 300,000 shilling fine, a jail term of 3 years; spreading child pornography, 20 million shilling fine, jail term of 25 years; for cyber terrorism, a 5 million shilling fine, jail term of 10 years; for hacking or illegal access, fine of 5 million shillings and a 3-year jail term. Yeah, pretty much that's it. So those are the different categories of crimes that have been listed. Mercy, let me start with you, because some have interpreted this to be, you know, punishing online users for their internet freedom or restricting it as an attempt to rein in on journalists and bloggers who publish information that affects people in power. Others still say that this law protects citizens from cyberbullying and harassment. But at the bottom line for many people is the debate around free speech. What freedoms do I have, and is the state allowed to restrict that? You know, can it clamp down on my opinion, etc.? What's your view?
Okay, thank you, Anne. I think this law on computer misuse and cybercrime is a law that's very timely, because increasingly we have seen Kenya adopt the e-platform for delivery of services from government to citizen, from business to citizen. And a lot of the services are increasingly migrating to the e-platform. So because of that, it is very important as a nation to step up our commitment to ensure and foster safety and security on that platform. But as that happens, we have seen the kind of resentment that has come on the fact that perhaps this kind of rules and the offenses are actually curtailing freedom of expression. But I would just like us to pull back a little bit and look at Article 31 on the freedom of expression that carries a safeguard that even as you put out information out there, the safeguard is that you cannot put out information if it harms the rights and the reputation of others. So this then carries an offense on fake publications, fake news, so that if a blogger or a journalist uses this platform to put out news, knowing full well that this is not accurate, it's counterfeit, it's false, but positions it in a way that suggests that this information is accurate, then this will be an offense punishable under the law.
Where do civil liberties then in the context of this law begin and end?
It's a fine line because we are entitled to enjoy the freedom of expression. It's part of our rights and liberties, but it's not a full-blown, unmerited right to be enjoyed. It carries safeguards so that if it goes to propaganda, hate speech, putting out information that defames and offends others, then it's a fine line which perhaps will be for the courts to test the limits on where that line will be drawn, because unlike other traditional media, which perhaps had a limited reach, the internet has a veritable reach. And many times you find that fake news, unlike real news, is so sensational that it goes viral.
And on the same grounds, then how enforceable is this law in an age where, you know, okay, sometimes, yes, you're dealing with a fake user, but other times, you're dealing with bots and all sorts of stuff that is, just sort of keeping this thing
running.
going. Yeah, so
yes.
how
Yes.
effective is it?
Yes. So this is actually a very complicated area because even prosecution and evidence gathering in this area is very sophisticated. We are opening up into the age of digital forensic. It's not a Kenyan thing. This is a global experience. And this obviously will call for building up of skill and capacity among the many actors that will be involved in the implementation of this law. The Communication Authority, the police, the Office of the Deputy, the DPP will be involved in stepping up the skill and sophistication to deal with the IT, the encryption and the technologies that will be at the back, including the bots that you mentioned. But even with the most difficult and long journey, we have to start with one step. But the goal and the commitment is to uphold the rule of law, to ensure safety, trust, and confidence, but at the same time ensure that we are able to uphold the freedom of expression as best as can be.
For
on this
those who
platform.
read notoriety in it, to the extent that there are laws, for instance, on defamation, etc., which they say would be able to cover part of what this law is talking about, and therefore its introduction is to clamp down on dissent. What would you say?
I think it's a legitimate concern because there are laws on defamation that exist. This computer misuse and cybercrime law is about computer-related offenses. So it recognizes the veritable power of the internet and technology. And this is why you noticed when you put out the offenses and the penalties, you see that these penalties are very, very, very high. Very much unlike the traditional kind of penalties that we have. And perhaps even as people come out to raise resentment, they should ask why. That why did Parliament pass this kind of a law that has these very huge penalties? It is because of the recognition of the tremendous power and capability that technology carries. So that while defamation could happen on a written hard copy publication, you can imagine what happens when that goes online. And we have seen, especially perhaps celebrities, encounter hate speech and all these kind of offenses online. Maybe you have been a victim. I know.
Oh, me never.
Jimmy Gates certainly was a victim of cyberbullying.
Right.
And when it went online, it went viral. And I believe as a result of this kind of experience, he has started off a campaign which carries the tagline, Kabla uklik, fikiria. Because that click has the capacity to go all over the world in an uncharacteristic and traditional manner because of the new information age.
Finally, as I bring in the rest of my panel, there's a general thinking in law that a law cannot act retrospectively. Yet, as you talk about the power of the internet, the fact is that it is sort of retrospective in its nature, to the extent that once something is there, the internet does not forget. So will this law be able to address things that maybe were posted a year ago, 2 years ago, or does it only take effect to supposed crimes that take place after it was, assented to?
Yeah, you're right. Law is proactive. Law looks forward. But in the process of cleaning up and fostering that trust and confidence, there will be efforts to try and clean up. Because remember, the scope of this law is not just to prosecute. It's also to create a deterrent nature, to create a protection especially for vulnerable populations of people who've been harmed. So I want to believe that this law will begin to set the steps that would enable people to take corrective actions, for example, to remedy their digital footprint, to enable them to remove content which is not factual, that needs to be removed, and some of it might take litigation and a court order to do that.
Okay, so I'll open it up to everyone else. Patrick.
Well, I think there are good reasons to be wary of this law, and I think it's a really bad piece of legislation as far as the what I consider attacks on freedom of expression are concerned. First, there is a reintroduction of criminal libel. That's what essentially 22 and 23 do, which was declared unconstitutional by the courts. As you well said, there are civil penalties, and there is a civil law that you can go to if you feel you've been defamed. Now they're making this a problem for the state, so the state will prosecute you for essentially, quote-unquote, defaming somebody. That's criminal libel, and I think on that basis alone, I think that's a section that's probably going to be litigated fairly quickly, and I think going by the precedent with KIC Act before and criminal libel 132 on the penal code, the way they were thrown out, I think this is a good candidate also to be thrown out. My other thing is, again, we are using the law as a hammer, I think there is a basis and a very good reason to leave, to let people and to encourage people to be more expressive online, and in other spaces as well. And instead of kind of using this laws or insisting that we've got to deter them from speaking, the internet and the things like Twitter have really allowed people who are previously kind of shut out from national conversation to actually be able to participate, to come in and say things. Now suddenly they're finding that there are huge risks for them to do it. Why are we imposing this? And I think that the reasons that this is coming to fore have very little to do with actually sort of cleaning up speech. I think a lot of it is about protecting, if you will, or clamping down on dissent, protecting the reputations of politicians, if you will. And I think we need to be wary about that. I'll say one final thing. When it comes to the purveyor of fake news, there's two questions we should ask. First, when we criminalize false information, putting out false information, who determines what information is false? The second thing is the government.
Fact.
Well, facts can be disputed. Facts can be, who is it? Who becomes the arbiter of whether this is fact or not?
But Gadara, something either happened or didn't happen. That cannot be vague.
Well, actually, there's lots of vagueness there, in terms of what actually happened. Lots of these things are reported, So you weren't there, I wasn't there, etc. So it becomes an issue of discussion. That's why people, to establish fact, there are certain procedures, even in science, etc., to do it, to get at it, But the question still remains, who determines what is true, what isn't? Are you going to be punishing newspapers, for publishing online a report that they thought was correct and it turns out it wasn't? Is that where we're going? I'm just asking. The second question I think
isn't the answer yes, and we do get, and that's why the burden is on us journalists to really to have our.
Yeah, but do you want that to be? But that then when you put that as a criminal sanction on that, what you're doing is deterring the reporters from going out because they don't want to risk, and that has a consequence on the reporting that you get.
Right.
You
people will go back.
Essentially,
right.
It will just have a chilling effect. What people can say. The other thing I wanted to say was one of the biggest purveyors of false information online is government itself. Remember Westgate. So if something similar happens, is there going to be a commitment that people in PSCU, it's not just bloggers,
Right.
that they will be held to this same standard? You know, when they put out information and say,
That is
we've
false.
built
Right.
10,000 kilometers of road,
Right.
and it turns out they haven't, are we going to see those guys being prosecuted?
Right.
You know, or is this just a law that targets the people that government does not like?
That's a fair point. Steve, your thoughts on it? That's a fair point.
Thank you, Anne. The incontestable fact is this. There's been an expansion about online presence without regulation. Now, if there is a digital platform that is unregulated, because it has not been regulated, it is susceptible to abuse. Enjoyment with responsibility, that is the technical design in the legislation. So I'd like to sensitize the public not to fear this legislation, because I've read it. And I want to point out the beneficial aspects of this law and how they can enjoy it with responsibility. Number one, it requires that everything you share regarding protection of reputation of an individual, remember the Constitution has put preeminence on the preservation of the dignity, privacy, and integrity of the individual. Our Constitution mentions the dignity of the individual 26 times, never appeared in the previous Constitution. So how do you animate that in terms of online presence? You have the right to express yourself, but you must balance that, we must make reasonable accommodation to protect the privacy, the integrity, and the dignity of the other person. If you say something that can occasion reputational injury, honestly, you must be held to account. There is no way you can escape that. Our penal laws provide for that. Only that in the digital platform, that was never covered for. Now, how do you know what? Let me answer Gadara. No, hold on. You know, the law and common sense are inextricably linked. You will know if you are sharing something that you are sharing information that you have not verified. It's about someone else. Information that excites you, you want to break it fast. You know, in the social media users, breaking news fast, sending as received. This law urges caution that whatever you are sharing, distinguish it from what Gadara is saying, like if it's just public. I'm talking about reputational injury to individuals who may not be able to respond to those allegations, to defend themselves in the manner that is so liberal as you're doing. Let us urge caution. Let us have online responsible activation. That is the design of this law. There is the other unspoken part, which deals with information infrastructure, critical information infrastructure, such as cyber crimes like
Right.
online, yes. If you are like, there is that
Hacking and things
hacking,
like that.
yes. So if you're involved in hacking, or maybe illegal mobile money transfers, that also deals with terrorism, you know, and maybe child grooming, like online grooming for children. The law now protects them against pornography. There are those beneficial aspects, but I think what people want to amplify is the limitation. For me, limitation must be seen through the lenses that for every action, you must reflect what is the level of accountability that is expected of you. If you look at it in that manner, then you will know when to stop. You'll ask yourself, what I'm sharing, does it touch on the reputation of another person? Have I given that other person an opportunity to interrogate this information? Or am I just circulating it for the benefit or amusement of my viewers or maybe followers without caring about the reputational injury? Who will fight for that person whose injury,
Whose
whose
reputation
now has
right.
been brought into disrepute? That is the critical question we must ask.
But Prof, I want you to speak to something Gadara said, which is, and perhaps I might want you to say it again, when you referred to truth and who determines what is true and false. I mean, is that even for real? Like, is there a truth, a half truth, and does this law, in your opinion, you know, give the burden of proving truth solely to the individual, or does the state take it? I mean, is it up to the state now to decide what is true and what is false?
That is fundamental, in the sense that if you look at Article 19 of our Constitution, it says that the rights which run from Article 19 to about 58, these rights are individual rights and are not given by the state. So here is a case where the state now is probably the one supposed to define what truth is, and absolute truth or relative truth. These are philosophical questions, but the point is, the biggest weakness in this legislation is how we are going to all agree on a parameter of truth. It's a national conversation we are beginning. The legislation is not bad. In fact, and cyber crime has ruined families. Cyber crime has displaced people from their homes.
True.
People who are abused. You are told, one time I made a comment on Twitter and I was abused by another guy. And the abuse was like, it was ethnic hatred. Somebody just saw by ethnicity rather than what the comment I was making. So this intimidates people. There are people who have been making a living in this country purely by sitting in a room and imagining this is happening about Steve Ogola or Kisiangani. Then they can start the story. They throw it online, and then it looks like true. It is not true. These people must be contained because we cannot continue like this. Before people, you correct your impression in front of your children, before you correct that impression in front of your relatives, friends, already damage has been done. There are some people who will never get a chance to see the correction. So in that case, therefore, the law itself touches on important things, and we need some form of regulation about this.
And that is and that is true. I mean, what happens to the individual? But if you could speak to the broader context of our country, our democracy, good governance, the fact that I think a lot of bloggers feel that they have in some way or form perhaps played a whistleblowing role, if you like. What would you say to that?
Yes, it's true. That is another challenge, and I was coming to that. The other challenge is this. What was, in some cases, what initially looks like false information has turned out to be true. For example, we have had serious cases of corruption. People have made claims about who has stolen which money. Then, it looks like a lie. As you put it, even some people in government say, this is a lie. But, it persists for 2-3 days, and then you hear that actually it is true. You see a parliamentary meeting, and then they start confirming what was initially rejected. Now, the guy who blew up this information to the public, by the time probably Parliament now establishes it is true, and you are already in the committee. So we need also a safeguard. That's my argument, that even in a democratic situation, there are certain things that we need to do to enrich this law. The law should not be criminalized. It just needs to be enriched in such a way that, on one hand, we don't want to take away the rights of other people, but on the other, we would like them to talk about things they believe are true, counter-check before they post them. And that means that while the state is doing its part, we as citizens need some form of responsibility. We cannot make millionaires who only thrive on false news. When other people are working very hard on the farms, in newsrooms like you, to make some coins, but there are others who just sit there to spread fake news. They cut off part of your body and on internet, and remain with another part and paste one other part to another person, and then say it's you who was doing this, Steve Okola.
my gosh.
This one is not acceptable.
Yes.
Allow me to say something.
Please go ahead.
What this law has done is recognize the special place that Kenya finds itself in. Kenya has one of the fastest speeds of internet in the world. It has one of the highest access in Africa. So because of that, you find that the experience that is being had in Kenya is very similar or can be approximated with experiences in the West. What does that mean for us, for our children, for businesses, for government who continue to use this platform? So in developing this law, what happened was that the people who designed this law stepped back and tried to capture the experiences, the good, the bad, the ugly, and try and put it up together, and then try and put penalties and sanctions that would safeguard this area. The law is merely a tool of social order. you know, it cannot be the only one way to create a solution.
I'm interested in
Yeah,
on whistleblowing, Gadara, and if you would, for a minute, indulge us even on that, to the extent that if you remember, and it has become a bit of a tradition around election periods, that you will see things being posted, for instance, logs. They could be from, you know, servers, or it could be phone records, or whatever it is, and without speaking to whether they are authentic or not, if we would suppose that they do play a kind of whistleblowing role, and in that way contribute fundamentally to our good governance or strengthening our democracy or safeguarding it in that respect, when you talk about hacking and things like that, I mean, is a whistleblower protected by this law, or are they criminalized by it?
They are protected by this law, because even for anyone who will come and allege, you know, fake news, fictitious news and all, there will be a standard. And even when the best laws are written, there are gray areas, which makes it business for the courts to actually come in, test these issues and create jurisprudence out of it. So as he said, I wouldn't look to it as a tool of terror and fear. It is just trying to put safety nets and parameters, and where there seems to be no clear line, the courts exist to try and clarify those areas. But for the best part, this law is good. This law captures the reality that we have experienced as a nation. It captures the reality that other jurisdictions have experienced, because we want to step up and be competitive in using of this platform.
I'll say two things. First, we shouldn't really run away from the issue of criminal libel and the reintroduction of that. Ogola is saying, Steve is saying that there was libel law, the Archive libel law did not cover the online practice. It did. If you libeled somebody on the internet, you know, they could take you to court. That protection existed, you know. So what this does is to make it the business, not just of you as an individual who feels somebody has said, has defamed you, and you want to take action, to make it the issue, an issue for the state. Now, there's a big problem with that, and that's why it was removed from our books, you know.
The problem being? The
problem, in essence, becomes, especially when it comes to people working in the media and stuff, that it has a real chilling effect in people being able to speak, you know, especially, you know, about politicians and whatever, because lots of the cases that will tend to end up there are going to be the cases that government wants to prosecute. You know, and those cases are very much, and you've seen, for example, how they would use the laws that, like Kika Act, all these vague laws that they had, to go after who? Not after people in PSCU who are putting out, you know, really false information. They would go after bloggers who are actually saying the things that government doesn't want you to hear. You know, and I see this being used in a similar way. You know, and I think criminalizing libel and putting criminal sanctions on it, you know, simply opens, starts to restrict rather the space within which journalists feel safe in writing about stuff.
But let me say this to you, Gadara, because I do agree and disagree. For instance, even in our own newsroom, the very high standard to which journalists are held to account by their own editors, leave alone the state, etc., before they publish anything. I mean, sources are checked and counted. It is simply good practice of journalism that you cannot run with something that you do not have concrete proof of. And I suppose that any upstanding media organization in this country, you know, you don't even need the law for that. You know what our code of conduct is. But I certainly do think you do make, and in that respect, I mean, would not intimidate a true journalist from doing their job, because there is that very high standard without the law that is imposed by our own code of conduct.
But the point is, it did intimidate people. You know, it's the same effect. If I may give an example of when you have huge awards for in libel actions, if you give be worth 20 million shillings because somebody wrote, or a bookstore carried a book that defamed him. You know, what does that actually do? It has an effect, and it's not just enough for you to argue that, well, if people will actually behave themselves and do everything by the book, then they won't be affected. It does place fears in them. And we've got to balance this, because what we are losing when journalists can't go out and write, when bloggers can't go out, you know, and carry out an argument, you know, for fear of the huge impact that they will get.
For instance,
you know,
the personal, having to pay those personal fines.
Not just paying the personal fine, now it's actually go to jail, you know. Then that means that people will be quite reticent to be expressive, to speak. And what that does is start to shut down the space that we have. And I think we really need to pay attention to that and to ask whether or not this is something we want. Criminal libel, if you're saying that this arose from, you know, we've got internet speeds like the West, and we are getting sort of a similar circumstance, go to the West. It doesn't exist. You don't have criminal sanctions for libel.
Steve, if you'd respond to what Gadaria has said on imposing the same sanctions on state officials who themselves spread propaganda,
especially during elections,
falsehoods, etc., that they should be held to an equally high standard.
But there's something that we must clarify for the viewers to understand. This law will not alter or impact negatively on public inquiry. You know, inquiry in the order of governance. But it seeks to limit how you interact with information that are personal in nature, information that may trigger reputational injury, whether that person is in a public space or private space. That one, that's a beneficial aspect of the law. But the nature of our governance, public participation, interrogation of how you are governed, that's allowed by the law, and this law will not alter that. If you are interrogating or questioning how money is being applied, public funds being applied, that's okay. And you can always be protected by the law, this law and any other law, including the supreme law of the land, the Constitution. Now, that distinction needs to be maintained with clarity that the law provides for it. What this law seeks to provide is to ensure some sense of responsibility for your action. You are not allowed, even by common sense, to propagate information which is not verifiable concerning a third party who has no opportunity to respond. How is that harmful? That's the first thing. But if I'm in a public office and I have the responsibility of applying public funds, yes, it's open to you to interrogate how I'm applying public funds. Then it's upon me to come out and clarify the funds as used. But you also must know the limit in terms of graduating your level of inquiry. You must make sure that you restrict yourself to the office, not the person of that office holder. That is the technical design in this law. I think if we get that critical balance of what the law seeks to achieve in terms of protecting the privacy and the reputation of individuals, whether they're in public or private spaces, we understand that without necessarily or unfairly or unduly limiting your ability to interrogate the technique of governance. That will always happen.
But if you could respond quickly to what Gadara has said then about public officers being held to the same standard in terms of the information that they equally put out on social media, that it may be in itself fake news.
Well, if a public officer promotes information which is untrue and incorrect, then they're not even qualified to be in that office in the first place. But to answer Gadara, there is the Whistleblowers Protection Bill, and you know these laws must be read harmoniously. Once that bill has been passed into law, it will provide mechanisms for whistleblowing and protection in that space.
But Steve, I want an answer. When the government goes out, or let's not even call it the government, when any political actor goes out and has their propaganda, it could be your local MP saying, I've built this, it could be your governor, I've cleaned that, whatever. But it is clearly untrue. Does that not fall in the category of fake?
I mean, no one is above the law.
No, if you open yourself, if you promote information which you know.
No one is above the law.
No, I think what Anne is asking, which is critical, how can we implement that if the mighty are the ones passing, propagating this false information? How do we catch them? It's very easy to catch Steve, but what about them?
That law will be used to target.
Time.
But just one last thing, and Steve is not addressing.
We're out of time.
He's saying that he's not addressing the fact that we've moved beyond a civil sanction which is provided for in the Defamation Act, to a criminal sanction. That has already been declared unconstitutional, and I think this will face a similar fate.
Okay, guys, you need to come back on Citizen Extra. They have a lot of time. That's all I can say. I thank you for your views. Thank you for your contribution, and also to Judith Ongori, who had joined us earlier. That's our time. Thanks for watching. Be careful what you post, eh? Good night. God bless. Bye-bye.